I think we're going to go ahead and get underway. My name is David Meyer. I'm the dean here at Tulane Law School, and it's my great privilege to welcome you here for this event. This is, of course, a very special occasion to have the opportunity to partner with the Penn Alumni Club of Louisiana in hosting this very important event. The subject matter for tonight's event, wrongful convictions and criminal justice reform, is of course a very important topic for the nation, but also with special significance here in Louisiana and of special significance to our own faculty here at Tulane, many of whom have long running concern and connection with this cause. It's also, of course, a wonderful opportunity to celebrate through the collaboration with the Penn Alumni Club, the deepening and broadening links that we have between Tulane and the University of Pennsylvania in the person of our new president here at Tulane, Mike Fitz, who was for 14 years the dean of Penn Law School before coming here, and before that, for many years, a member of the Penn faculty, and I think a Penn faculty brat before he ever joined the faculty. So it's a great, I'm very excited and grateful to the Penn Alumni Club for the opportunity to join in this program. So my main task, besides welcoming you, is to introduce the three speakers for tonight's event, and then I will step out of the way. I want to begin by introducing John Thompson. Mr. Thompson, who and tell you just a bit for those of you who welcome. I imagine that most people here know his remarkable story already, but in the event that there are a couple here who do not, I will remind you that in 1985, when he was a 22-year-old father of two, he was wrongfully convicted of murder and sentenced to death row at Angola State Penitentiary. While facing his seventh execution date, a private investigator hired by his appellate attorneys from a firm in Philadelphia discovered scientific evidence of his innocence that had been improperly withheld for 15 years by prosecutors. The investigator found a microfiche that previously unknown to Thompson's lawyers that contained information about the blood type of the individual who had committed the armed robbery, which did not match Thompson's. Thompson was released and exonerated in 2003 after 18 years in prison, 14 of them on death row. The jury at his retrial took 35 minutes to acquit. And thereafter, upon his freedom, he sued the district attorney's office, resulting in a jury verdict awarding him $14 million in compensation, $1 million for each of the years he spent on death row. The state of Louisiana, appealed that judgment, which went all the way to the United States Supreme Court, which ultimately overturned the judgment in a 5-4 decision authored by Justice Clarence Thomas. In the years since then, Mr. Thompson has been the founder and director of Resurrection After Exoneration, a New Orleans-based program that provides exonerees with assistance to rebuild their lives after their release from prison. And the program has so far helped a number of exonerees get back on their feet through job training, clothing donations, health care, and counseling. Our second speaker is John Hollway, who is the executive director of the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Law School, where he also serves as an associate dean. The Quattrone Center is a national research and policy hub focused on the United States criminal justice system, and I should mention that our president, your former dean Fitz, played a crucial role in the launch of that center during his time at Penn. Mr. Hollway is a graduate of the University of Pennsylvania for his undergraduate degree and the George Washington University Law School. He worked as a litigator at a major Philadelphia law firm, and in a variety of senior management and leadership roles in the healthcare and pharmaceutical industries before returning to Penn to lead the Quattrone Center. He is also the author of Killing Time, an 18-year odyssey from death row to freedom, about John Thompson's remarkable story. The book won the National Independent Book Award for Nonfiction in 2011 and was one of the Chicago Sun-Times Best Books of the Year in 2010. And finally, our own Professor Pam Metzger, who will serve as moderator for tonight's event, is a national recognized expert on criminal procedure and ethics in the criminal justice system. Most recently, in part in collaboration with the Quattrone Center, she has been exploring how data-driven systems approaches to high-risk practices can improve the delivery of public defense services. Before joining the Tulane faculty, Professor Metzger served as an assistant federal defender in the southern and eastern districts of New York and worked in private criminal practice in New York City. She has been a visiting law professor at Washington and Lee University, where she directed the Alderson Legal Clinic for Women in Prison. In 2001 through 2008, she directed our own criminal litigation clinic here at Tulane, where she became a leading voice in criminal justice reform in New Orleans and throughout Louisiana. So thank you all for being here. We're very honored to have your participation in this important program. So Pam, I will now turn it over to you.
Well, come on up here, John. I don't have much to do at this point after those introductions other than to say what a pleasure it is to have both Johns here and to ask John Thompson to kick things off for us. The floor is yours, my friend.
The floor is mine. Because you always get me in all this trouble. Good evening. And thank y'all for, once again, I would like to thank Tulane and Professor Pam for having me, asking me to come out, and John. Well, when we're dealing with the subject of wrongful conviction, for the last, I think, 8 years now, I've been really trying to get a better understanding of our criminal justice system and how it played a role in my life and how it really affected me and why some of the things happened, and it was kind of crazy. And so y'all law students, which better place to try to explain it and hope I could get maybe some kind of clarification on what happened to me. Because I can understand that I was accused of killing one of the richest men's sons in the city, and I can understand that peer pressure was on the criminal justice system to bring someone to justice here. I was an African-American male accused of killing a very rich man, and he was, I believe, Italian, native. I don't believe he was Caucasian. I'm trying to put it together because I want to make sure it sounds right. It's not don't sound racist, because I feel like it was a whole race game played against me. And so I'm trying to, when I'm in an audience like this, I'm trying to be careful on how I'm saying it, all right? Because I don't want no one to think I'm coming off racist. So right away off the top, they arrested me for first-degree murder. 6 feet, I was supposed to have been 6 feet tall. Supposed to have been a big, broad man with a bald head. You know, when I seen the murder on the TV and I seen Crime Stoppers placing all of these warning signs, I said, wow, someone in trouble, you know, because not only did I see all the Crime Stopper signs, but when I went into the grocery stores around my community, I seen poster signs. And I was like, wow, you know, it's really going to be a mess in our community, because then as the weeks went on into the murder, the investigation, the traffic got heavy in the community with the police department, so the pressure was on the city to make some form of arrest. National Guards was called in. At the end of the World Fair, this happened, y'all, so you got to understand that the city was already in trouble because of the World Fair, because of all the crime and everything that had happened at the end of that year. So he was already in trouble, so when this happened, it just blew it, because this is just so happened Mr. LaLusa was a part of bringing the World Fair to New Orleans, too. So this is how deep this really was. It wasn't only about the world felt about him, his partnership in the world felt, but it was in his partnership with the city itself. He not only had the World Fair in plan, he also had the convention plan too. So he was a very important man to which I believe made our district attorney office in our state behave the way they behaved in my particular case. Being charged with first-degree murder on January the 17th, only not to cooperate with anything, only to find myself a week later charged with 6 more counts of armed robbery. Meaning that people claim they seen my picture on the newspaper and called the police and said I'm the one that robbed them. In these particular cases, all the robbers was 5 feet 7, 5 feet 8 with a big bush along afro, and I fitted that description to a T, so it was easy. They brought me before the court and tried to bring me to trial for this procedure, to which I think where the system first broke down on me at this proceeding, at this hearing procedure that I went to. I was supposed to be going in there for arrangement for my murder charge because my attorneys had a problem representing me, so they didn't want to get off the case, so the court was going to appoint me another attorney. And as I was in the court being appointed attorney, 3 kids was in the courtroom that identified me and said that they was identifying me in a robbery. During this procedure, it was a murder procedure, and it basically just was reappointing me attorneys. At the time that this was going on, a request was made for my blood to be withdrawn. A whole lot of action was happening during this process. We had one lawyer being removed off a case. We had another lawyer being placed on the case. You had a DA on this side, slick side, asking the judge for my blood to be withdrawn. You had the judge granting him that. You had the court reporter trying to catch everything that she was hearing because she was hearing a combination of things. And so now you got some important information winding up in the wrong records. You got a robbery case going on now and a murder case going on now. You got the murder information winding up in the robbery information, and the robbery information winding up in the murder. The crazy part about it, these 3 kids was in court identifying a man that they claimed they knew to have a big bush, but now I'm sitting up in front of them with a bald head. So it's like kind of understanding that what's really going on now. How these 3 kids that identify a man in the newspaper with a big bush, but now they're identifying someone before them a week later that they only seen for a minute, at the most they say, and now they identify me in open court with a bald head. So they really seen me that good that they could identify me, and the court allowed them to proceed with this case. So this is where I thought something kind of went crazy, because the same prosecutor, his name was Jim Williams, who requested to have my blood withdrawn. Not the DA who drove the evidence away, but the DA who requested it was Jim Williams. And so that this DA was the same DA working on my murder case as well. Now, when these 2 DAs finished answering and dealing with the motions and stuff for my murder case, that's when they decided to push the murder case on the side and pursue my case with the robbery, and pursued to take me to trial for armed robbery. I went to trial for armed robbery within, I'm assuming about 80 days or 90 days. So after I was arrested 90 days, I was found guilty for attempted armed robbery. The kids say I robbed them, and we struggled, and the blood kicked me in my face, and he pulled me, and he jumped out the car, and I ran, and he had the gun, and the gun went off, and the police came. And this was a history that they took all the pictures, they had all the evidence, and they did everything under that. And so I guess they figured that, since you ain't gonna testify for us in the murder case, we would use this against you and use this and hope you testify. After convicting me for that, they came and asked me again, would I testify for them and tell them the truth about the murder case? And I'm kind of confused. I'm like, wow, you just convicted me of something that I ain't doing. Now you come and ask me to do the same thing. And they let me know that they wasn't playing a game. They took me to trial for first-degree murder. They got the individual who actually did the murder, say I did it, and boom, they convicted me and sentenced me to death row within 120 days for 2 crimes I didn't commit. The same individual, the same district attorney, Jim Williams, in both cases. So then I'm on death row, and I'm like, wow, because the lawyers that he gave me was Norman Bird telling them that represented me at the murder that said they couldn't represent me because they know the victim family. And so they took the public defender case off of my case, and they put a private attorney on my case, which was Patrick Family and Rob Cooley. And I'm thinking, I might be all right now, because Patrick Fanning just came out of the federal court office, so I know he was a good attorney. He got to be an excellent attorney. He worked it for John Volks and them. And then here come Rob Cooley, Adam and Reeves. Oh, man, I got me 2 good attorneys. That's what I'm thinking. And the first thing came out their mouth is when I plead guilty. That's the first thing they walk up and told me. And I'm like, wow, plead guilty to what? The best we could do is save your life. I'm like, wow. The best thing you can do for me is get away from me if it's anything. And so then we went into this relationship like that, a negative relationship that we couldn't communicate at all because they was telling me to plead guilty to something I didn't do, and they feel like they were wasting their time. And to the point that one went in court and tried to withdraw from the case, and he couldn't withdraw from the case. So since he couldn't withdraw from the case, he called himself arrested. He just didn't want to fight at all for it. And basically, if you're looking at me while I got sentenced to death, you'll see he just didn't feel like fighting for me at all. You'll see basically he introduced a psychiatrist that said I'm the type of person that wake up and looking for people to kill. And this was my attorney put this type of witness on the stand. Once again, I'm feeling like it's a conspiracy. I got I believe 11 whites and 10 whites, 1 black and 1 Hispanic, I believe, on my jurors. It feels like a conspiracy to me. We had one of the, I think, fastest true trials in history in Orleans Parish, 2 capital cases that no lawyer in this city, I believe, could prepare for a capital case that fast. And I had 2 of them, and one of them still couldn't prepare for a capital case that fast. And so, once again, it feels like a conspiracy, and it feels like, people seeing what's going on around me, but really nobody don't care because I'm poor, I'm African American, and I'm accused of killing someone. But then I said, wow. Well, they did all of this here to convict the innocent man, and the next thing I hear, the person that's accused of this was killed. I'm 10 years into my sentence, fighting like hell to free myself, trying to get everybody in the world to hear my plea, begging, writing every law firm in the country before I've been blessed with Morgan and Lewis hearing my plea in '89. That's what they heard the plea. So I'm on death row. Really, no education, just happened to find a law journal that had the top 200 law firms in it that year, and I'm deciding, no, I'm sitting here going to write every one of these law firms because somebody's going to believe me. But it was kind of hard to ask someone to believe me because I'm asking them to believe that I was innocent of 2 different cases. I got found guilty of 2 different cases. People like, even my lawyers that represented me on a murder, I was like, I had to beg them because my time was dead. Then came with this new federal rule where you had to have your 2 years in, you got to put it in or you procedurally barred. And so when he shot that in '89 or '90, whatever that was, when he shot that law in, well, everybody escaping in prison because no one had attorneys. So everybody had to try to find a way to put something in court to try to save themselves. And so I had to beg and beg and beg, and finally the lawyers realized that, well, it ain't going to hurt us to file this. And they filed it not because they really wanted to file it. They filed it because it was a procedural thing, and they just didn't want to see me, I guess, keep on complaining about being procedurally barred. And good thing, because that is what saved my life. Not the murder case, not what happened in the murder case, not all the crooked, wicked things that they did in the murder case, but that case that nobody didn't want to mess with because they thought it wasn't important. They thought, we got to worry about you saving your life. You worrying about this little robbery case. I'm like, don't worry about both of them because I'm innocent of both of them. Y'all could say that on one, but I'm telling y'all I'm innocent on both of them. And so now when we get to filing appeals, and I'm getting to feel good because now Crime Stoppers, who I think is one of the corruptest organization out here in our system, and we feeding it. When you actually paying the people to break the law, you cannot pay a witness anything to testify. But yet Crime Stoppers doing it and we accepting it. I'm sorry, something wrong with us if we accepting these kind of things that's hurting in our criminal justice system, because them are the kind of things that reversing all the cases when we find out that the district attorney did all these sneaky things. But yet Louisiana Supreme Court give me a evidence right here on Crime Stoppers. If I could prove that they paid these people this money to testify against me, I'm going to get a new trial. Boom, I prove it. Got Crime Stoppers to testify. I can put them on the stand. We prove everything. Everything they wanted to prove, we prove it. Look like some kind of way the Supreme Court must have realized who or what case they ordered this on. For some reason, They denied me when I came back, even though we had all of this proof. Everything they asked me to prove, we proved. Crime Stoppers got on the stand and said, oh, yeah, we paid them before and after. They testified. That's what you can't do. But yet, my judge said on there and said, I was there, and I seen it all. And you know what? I think the jury knows that these people received the money. I don't think they lied to anybody. I think the jury knows it. So he hit me with a fact finder. And he realized, he said, they took his word, and he didn't agree with me. They didn't give me no relief when I came to them. So I was like, wow. Same thing would happen to me. 3 years later, I'm in front of the Fifth Circuit now with a Bastion issue. I'm just knowing. This attorney used all this. He was so crazy, he made a prima facie showing when he even had to, because Bastion's case wasn't even in the court system yet. But my lawyer, Patrick Fannin, the only thing he did right, made that Bastion claim. And that happened, and he challenged it, and the judge said, oh, this ain't a Bastion claim, I don't know what it is. That's Mr. Stood in the Fifth Circuit, and boom, by y'all. For whatever reason, they denied me without opinion, without nothing, even after going through all of these. So every time we get in court, my lawyer's really feeling like, we got to win, we got to win, we got to win. We get shut down, we get shut down. And then all of a sudden, I don't know, at 99, everything popped open, everything happened. Everything was revealed, what happened, what they did, and all. What really started transpiring after that is another aspect of our system again. Because now you tell me I got to sue them, you tell me I got to file complaints. When I thought every petition that I filed was a complaint. The Bar Association telling me I got to file a complaint against this attorney. I got to file a complaint against that attorney. I said, damn, but what that brief was that my lawyer filed that got me free. What do you call that? I'm trying to understand what is a complaint. Because our Bar Association, our disciplinary board, playing us for a game. If you do anything to your clients dealing with money, they're going to suspend you, they're going to take it out. But yet this district attorney could do anything with no consequences. So when I get to the Fifth Circuit, and the Fifth Circuit decided that they want to hear my case, you want to hear a 3-judge panel on case. That was kind of weird. 3 judges ruled in me, give me the $14 million. He could have it. He did deserve it. But somebody called an en banc hearing. Who going to override 3 judges? 3 judges in this state agreed with me. And so somebody somewhere on the slick side called an en banc hearing, and now you got them reconsidering, trying to override 3 of their own judges. Something funny here. I don't care what y'all say. To me, something is kind of conspiracy going on with the power or the structure around this particular case. Because now you're going to override a 3-judge panel, federal judges, and guess what happened? They did. They overrode it, and then they came back with an 8-8 split decision that forcing the United States Supreme Court. Not really forcing them, but now they could look at it. Because now we got a problem in our state. We got a state that got federal judges is confused on something that we should settle. When actually I had a 3-judge panel ruling all 3 judges in my favor. So what I'm saying here today is I'm saying that we got a system that no matter how good we want to claim it is, we got individuals that can make it change. And I believe that's when we need to hold, and that's why we should always be seeking to hold people accountable for the action. You can't tell me if I was executed because of not just me. This man I keep calling name is Jim Williams. He put 6 of us on death row. All 6 of us cases was reversed, and he's still out here practicing law. He sent his children to college. He took care of his whole family by now. And for to say that he's still around practicing law, I mean, that's a total disrespect for everything that this country is supposed to stand for and the law system is supposed to stand for. So with that, I just ask that we try to start really considering how we should hold these people accountable. These people have our lives in their hands, and especially when you speak in terms of if all 6 of us would have been executed. Right now we have 10 men in this state been exonerated. 6 of them is his. What more y'all need to know? So if this is not attempted murder, if this is not some form of corruption that the system just deliberately turning the blind eye to, even though the Supreme Court said it wasn't a pattern, this man got 6 cases himself. They looking at a dead man. They looking at a man who played a second seat to all of this. He didn't have nothing to do with it. So I thank y'all for having me. I hope I tried to share a little different light on our system, because I think we do have a good system. We have a bar association that don't punish, that they say they want you to file a complaint to complaints that's already been filed and answered and really delivered with what happened. When you listen at a Supreme Court ruling, They clearly tell you what happened in the case. They clearly tell you what happened. If it's a misconduct, they're going to say it's a misconduct. So Bar Association, y'all don't need nobody to file no letters. The highest court in the land then clearly told you what happened in this particular case. So you don't need to use us as an excuse as why you're not trying to keep our system safe. So thank y'all for hearing me. And I hope.
Thank you, John. So it's always nice to do a talk with John, because when I do a talk myself, I get like 4 people who are kind of interested maybe in some of the arcane stuff about the law. And then when John comes, all of a sudden I'm talking to a room full of 80 people. Because there's really, I wrote a book about John, and that book has blessed me and, in so many ways that I could not have predicted, and led really to the Quattrone Center for me. But hearing it from the person who's been there is, I think, a very special experience. So thank you very much for coming to do this with me, and for everybody here. I also want to acknowledge in the back Robert Glass. Robert was one of John's attorneys in his retrial. The retrial, by the way, John was acquitted after a 35-minute jury deliberation. Now, how many of you have ever been on a jury? Okay, so that's actually more than I would have expected. The fact that almost none of us have been on juries, including me, is, I think, a tragedy in our criminal justice system. But 35 minutes of jury deliberation is like everybody sits down and they go, well, there's no way this guy did it. Let's have some Danish and go tell the judge. Right? I mean, it's nothing. And it suggests that the trial was an open and shut case for all those jurors. And Robert is a big reason why. So it's lovely to have you here, and thank you very much, and thank you for the work you've done. So I'm gonna take John's story and build on it to talk about some of the initiatives that are now happening to make sure that what happens to John doesn't happen to people in the future. And it's funny because I got involved in the case because I used to work at Morgan Lewis, and I knew the attorneys that had represented John. And in fact, one of them lived down the street from me, and we would get together for drinks after work and stuff. And one day, I had known he was representing a death penalty case, but I didn't know much about it. And I knew it was going very, very badly. Like, the Supreme Court had overturned their final appeal. John was scheduled to be executed in 5 weeks. And Gordon had gone down to New Orleans to tell John that he was going to be executed. And, I think John talked a little bit about the struggles that he had just to find an attorney. But it took him 4 years just to find an attorney. And when Michael and Gordon took the case, they didn't take the case because they believed he was innocent. They took the case because it was a death penalty case, and they believed ardently that the death penalty was a bad thing and should be fought. And one of the attorneys believed that it was bad on moral grounds. The other one believed that if you were going to have the ultimate punishment, you needed to have ultimate truth, and you needed to put it through its paces. And so for different reasons, they kind of came together in this case. But one of the things that's kind of always interested me about this case is that the reason that, as John said, he was convicted of 2 crimes, the murder and the armed robbery. And the reason that he was convicted of the armed robbery, and that the armed robbery was tried first, was that gave him a prior violent felony conviction, which allowed the prosecutors to change the charging in his murder case from a murder 1 case to a capital murder case. So basically, the whole reason for the armed robbery conviction was to be able to put John on death row. And if you think about it, if the prosecutors had not gotten greedy with the armed robbery charge, they would have convicted John of the murder, and he would have been in prison life without parole. And without life without parole, John doesn't get his pro bono attorneys. And without his pro bono attorneys and 14 years of hard work and a stroke of blind luck notwithstanding all that, John's not here today. And so one of the questions that was haunting me as I was writing the book was, the death penalty, in a sense, saved John's life. And so how many people are there that have life without parole that nobody is paying attention to because the death penalty hasn't, with all of its moral challenges and emotional challenges, brought attorneys in to represent? So that's number 1. Number 2, I was fascinated in this case because I didn't think errors happened in our criminal justice system. Right? I mean, I grew up in Annapolis, Maryland. Okay? It just sounds white middle class. Right? And that's because it is. And I grew up thinking, if somebody said on the radio, so-and-so has been arrested for the crime of such and such, I would think, oh, they got the guy. Right? Now I know, you can get arrested for anything, right? And being arrested has nothing to do with being guilty. But I just trusted the system, and I thought, okay, the system's going to get it right. If they've arrested him, they've done it. Then I started shopping this proposal for John's book. And every publisher that I sent it to said, yeah, we get a lot of these. We got too many of these. Write a magazine article. And I went, wait a minute, hold on. You get a lot of these? You get too many of these? How can that possibly be? And then I started doing a little bit more research, and I found out that, in fact, John's case, while I think it is one of the most gripping cases, there are way too many people in our prisons that are there and do not deserve to be there, are innocent of the crimes that they have been charged. And so I wrote the book. John wasn't sure if it was going to get published. Neither was I. We got lucky, it did. And I think his story is so gripping and it has affected a lot of people. It got me to the Northern California Innocence Project, because I was living in San Francisco at the time. And that got me on a book tour, and I was at Penn Law. And I got pulled aside by a development officer who said, I've got some wealthy alumni who are really passionate on this issue, and they want to know why we don't have an Innocence Project. And that conversation led to the Quattrone Center. What I had been thinking about at the time was what happens when there's an error in criminal justice, and what do we mean when we say that there's an error, that something has gone wrong? So the technical definition, if you could look at sort of organizational management or systems administration or engineering, the answer to the definition of an error is it's something that's unintended. So you've created a system, it's supposed to work in a particular way, and you have a plan on what's going to happen, and an error is when something unexpected happens, right? Now, there are different kinds of errors in criminal justice, and wrongful convictions is where a lot of the focus has been and should be, right? That is the most emotional and the biggest wrong, okay? So John and Killing Time is a story basically about bad prosecutors and the effect that it had on John's life and the relationship between John and his attorneys as they tried to fight it, and how difficult it is, how easy it is to get a conviction, and how difficult it is to reverse that conviction, even if it's wrong. And you actually just did something that, when I was sitting down to write the book, I thought was extraordinarily difficult, which was, how am I going to make 13 years of federal appellate litigation interesting? But so there are bad actors in the system, okay? But that's not the only kind of error that we have in criminal justice. So George Soliotis is a man who was convicted of arson and murder in Central California. And he was in prison for 17 years, I believe. And about 15 years in, he got a rehearing. And he got a rehearing on the basis of the fact that fire science had changed. So George was convicted of arson based on expert testimony. They brought fire experts in to look at the wreckage of the apartment building that had burned down. And these experts said, well, it looks like based on this pattern and that pattern, we think the fire was set in several different places, and that's evidence of arson. And based on the wicking pattern on the walls, we think an accelerant was used to enhance the fire and the blaze, and that's evidence of arson. So based on all these facts that we conceive that are science, we think that this was arson, and George gets convicted on that. And the only problem with that is that 15 years later, you won't find a fire scientist in the world who will say that all those things are arson anymore, because now we actually have new fire science, and fire science has progressed. And so one way to think about it is, George Soliotis was convicted on the basis of science that said that the earth was flat. And 15 years later, we now believe that the earth is round. And since there was no other evidence tying him to the blaze, we now say, oh, sorry, George, you're free to go. Now, the interesting thing about this is, John's story is bad prosecutor. I actually don't think that kind of junk science or the evolution of science is a bad prosecutor error. It's a different kind of error. It's an ignorance of the system error. Those prosecutors look at a case where people have died, and they go ask an expert, is this arson? And the expert uses the science of the day and says, I believe this is arson. And everybody testifies. How do you fix that? Well, we're not sure, but it's a problem that needs to be solved, and it's one of the things to work on. But it's a different kind of error than bad actor. And I bring it up because a lot of people, when something happens like what happened to John, or what happens to George, the first reaction we all have in criminal justice, because criminal justice is about allocating blame, the first thing we want to know is, who's the bad guy now? Who do we blame? Who gets fired? Who gets punished? And if you have intentional actors who are doing things bad, that needs to be held accountable. But I don't know who you punish in the George Soliotis case. It's just something that has to be prevented. Now, Glenn Ford, I don't know where he fits on the intentional side of things. But Glenn had a similarity to John's case. Glenn was in prison for, was it 35 years, John? Something, I mean, it was a very long time. Exonerated for DNA evidence. But the interesting thing in Glenn's case was that the man whose DNA matched the murder scene was arrested at the same time as Glenn and released. And the question you got to ask yourself there is, if the police have the guy in custody, why would they release him and go after Glenn Ford? Why not just keep the guy you've got, right? So for me, the Glenn Ford case stands for this idea that sometimes people just make mistakes. And I think far more often than not, we have police and prosecutors and defense attorneys and judges in these high-pressure jobs, these complex systems, highly dynamic environments, incomplete facts, unhelpful witnesses, high pressure, high stakes, zero tolerance for error. And sometimes we just get it wrong. And it's very easy to blame the person, but more than that, we need to understand the system. Now, when we have these errors, thank God for the Innocence Project, right? In 1989, the Innocence Project started using DNA evidence and got started, and that has grown. And we now know that as of today, there are 1,668 people in the United States who have been exonerated, found innocent of the crimes for which they were convicted. We're now finding new exonerations at a rate about 1 every 3 days in the United States. Now, it's not clear to me whether we're making more mistakes or we're just getting better at finding the mistakes, but 1 in 3 days, right? That's a lot of mistakes. And the thing is, that's only the tip of the iceberg, because 85% of those 1,668 exonerations come from cases that went to trial, which makes sense, because if you go to trial, then you can have an appeal, and it's in the appeals that we find this process. The thing is, only about 3% of criminal cases go to trial. So if you were to invert that fraction and say that 1,668 is 3% of all exonerations, now you're talking about close to 50,000 exonerations. Now that's crap data, right? I mean, there's no way of knowing whether it's 47,000 people. But 1,668 is the tip of the iceberg. You can tell because I've got an iceberg on the slide. But the question, the Innocence Project is great at litigating and redressing errors, right? So we find somebody innocent, we're going to sue, we're going to process that case, and we're going to make what we can do to make it right for you. But how do we prevent errors, right? That was the question that we started asking after this donor said, why don't we have an Innocence Project? And the answer was, because the Innocence Project is great at redressing errors, but how do we prevent errors? As Benjamin Franklin said, an ounce of prevention is worth a pound of cure. As an employee of the University of Pennsylvania, this satisfies my obligation to mention Ben Franklin in every public speech. So what we decided to do at the Quattrone Center was to say, well, let's not reinvent the wheel. And say, what have other complex systems that have the characteristics, the stress, the dynamic environments, the zero tolerance for error, what have those systems done to try and make themselves safer and more high quality and reduce errors? What has aviation done? What has nuclear power done? What has healthcare done? Just a side thing here. This is obviously a broken wrist, okay? And what they do is they say, yes, this is the wrist you should operate on because there are thousands of people who've had the wrong limb operated on. Now, this is not my wrist, but I have had this surgery done. And the doctor knew what I do for a living at the time. And we're sitting outside the room, and I've got my cast on, and he's giving me the prep, and he writes on the cast. And I'm like, dude, you're going to go in there and you're going to do what with the cast? He's like, I'm going to take it off. And then what's going to be on my wrist? How are you going to know which wrist it is? And he goes, you're a real pain in the ass. But I bring this up to make the point that clearly he didn't want my surgery to go wrong. And clearly he'd been trained. And clearly he probably does 20 of these a month. And yet he was still getting into a bad habit that created an environment in which an error could happen. And so it's that sort of attention to, the reason that he does this is that a bunch of people operated on the wrong limb, and they did so after asking, have you guys been in the hospital and they come to you, and it's like every person comes to you, and it's like, what's your name? What's your birth date? Do you smoke? Do you drink? right? And I would be like, John Holloway, 12/24/1970. Yes. Yes, more than you like, but less than if I have a problem. Right? But they're asking you those same questions every time because it's a protocol that they follow. And this is a protocol too. And even then, the best professionals can deviate from those protocols in ways that create error. And there's no reason to think that criminal justice is any different than healthcare or aviation. The only thing that's different is that criminal justice is an adversarial procedure. And when we get into an adversarial proceeding, we start getting competitive and we start getting moral. And we start thinking the person across the table from us is evil. And when that happens, we don't listen to the environment, we start getting the person. And that's when the debate goes off the rails. And we lose the ability to step back and think about how the system is supposed to operate and put better protocols in place to avoid what happened to John. Because maybe if we'd had a different environment in the Orleans Parish DA's office, maybe if we hadn't had a policy of trying to get the death penalty when you had murder one, maybe if we had supervision around the case or different protocols for what the crime lab is supposed to do with a blood test, maybe that crime lab sends that blood test like they do in Washington, D.C. They send 2 copies to the prosecutor, one of which is in a sealed plastic bag that says defense attorney. And they do that so the prosecutor knows that he can't hide that information, that he has to send it to the defense attorney. Maybe if that had happened, you wouldn't have had what happened to you. And if we were to change the environment, even with the bad actors, we make it harder for them to do what they want to do. So let's see if we can change the environments to do that. Now, when healthcare got started on this kick, there was a report issued called To Err is Human. And they said there's 100,000 preventable medical deaths in the United States every year. And we got to do something about it. And they said this is not a bad apple problem. The people that are involved in this system are almost universally good people making decisions that are unintended outcomes in a very difficult environment. And as I read this, I thought, that really applies here. There are bad people, but there are far more good people. And I talked to one of the authors of this, a Harvard doctor named Lucian Leap, and I said, how do you handle the error versus misconduct problem? And he said, look, in every industry that we've looked at, every industry, the good people outnumber the intentional misconduct people by 10 to 1, 20 to 1. But let's assume it's 2 to 1, right? You should still go after errors first and misconduct second. And there's a couple reasons for that. But the first reason is there's more errors. So if you go after errors, you're going after the bigger piece of the pie. But the second reason is there's 3 categories. There's errors, there's intentional misconduct, and then there's intentional misconduct that masquerades as error because you've got gray areas and things that are unclear in the system. If you tighten up the errors, not only do you reduce errors, and that's good, but you also get rid of that gray area where errors where misconduct can masquerade as errors. And that makes misconduct harder to do, so you reduce misconduct, but it also makes misconduct more obvious. So you can punish misconduct the way it needs to be punished. And actually, when you do that, the people in the prosecutor's office, they feel better about it because they know that they don't want the intentional misconduct either, most of them, but they have empathy for their colleagues, and so they see them in a positive light. They see the goodness in that person, so they're hesitant to have that person get punished. If you make clear that it's intentional misconduct, that goes away, and actually it becomes easier for everybody to see that dealt with the right way. So that's another reason why you start with errors. Also, I think we've now seen the case Brady versus Maryland is the case that says that a prosecutor has to turn over exculpatory information, right? That's in 1963. It's been 52 years, and we are not seeing fewer Brady problems. So some of that is because prosecutors have absolute immunity and there's no accountability. But I would argue that if you're still getting the same or more violations of a rule 52 years in, maybe you need to change the rule and figure out how to enforce, how to manage that rule and how to interpret that rule differently. So that's another thing that we're going to look at with the Quattrone Center, because I think the rule is broken, not the people. Errors are caused by systems, processes, and conditions that lead people to make mistakes or fail to prevent them. Now, this is a schematic in the bottom of the criminal justice system, but above that, the Swiss cheese, this is a way to think about a system and about the errors in a system and about what leads to a wrongful conviction. So the Swiss cheese model says that think about the system as a block of Swiss cheese, and think about every interaction in that system as a slice of Swiss cheese. And for each of those slices, the holes represent the opportunity for error. And what this shows, this is from a guy named James Reasons, what this shows is that Yeah, you've got active acts, right? So the guy who took John's blood evidence and threw it in the trash, right? That's a deliberate, intentional, unsafe act that can lead to an error. But then you've got preconditions for unsafe acts. So what allows this guy to do this and get away with it? Why didn't somebody know that hadn't been checked back into evidence? Why didn't somebody on the defense side know that the blood test had been done? Why didn't the evidence have some protocol, like I mentioned in D.C., to get to John's defense attorney? These are all environmental preconditions that allow those unsafe acts to happen. So if you take away those unsafe preconditions, then you make it hard for the guy to destroy the evidence, and you've hopefully reduced errors. Then you've got unsafe supervision and organizational influences. So unsafe supervision is prosecutors are left on their own. Like, nobody's really looking over their shoulders on an individual case-by-case basis. So if somebody decides that they want to go rogue, it's easier to do so. Organizational influences, that's like Harry Connick Sr., the DA, saying, I want to go after murder, any murder one that I can, I want to charge as capital murder. Right? Now you've got the head of your organization giving you an incentive to try and charge aggressively. So what are you going to do? How are you going to interpret that in the culture of your organization? You're not going to only charge what you think you can prove. You're going to put that on the jury or the defense attorney to catch you as you try to charge aggressively, and obviously that's something that could lead to error. So all of these things happen, and what the idea of the Swiss cheese model is we have checks and balances in the criminal justice system and in any other system. So here in the checks and balances, we have discovery rules, we have the public defenders or the defense attorneys, we have the judge and the jury, and they're all supposed to be overseeing this so that if prosecutors go too far or law enforcement goes too far and they do something that overrides our constitutional rights, we can catch them, right? And so a lot of these things will get caught. So you might have an error in the first case, but it'll run into a slice of Swiss cheese that doesn't have a hole at that same point, right? And it's only when each of the interactions has an error that goes all the way through the block of Swiss cheese that you get your Challenger explosion or your Fukushima meltdown or your John Thompson wrongful conviction. But those are the events that you have to pay the most attention to because those can reveal to you errors that happen throughout your system, right? So that broken wrist example I gave you, there was a paper done on a broken wrist in healthcare, and it showed 17 different protocols that had been violated in the same procedure. And any one of those 17 violations would have prevented the wrong side surgery. And it's only when they all line up. So you might think, well, it doesn't happen very often. We don't have to pay attention to it. But in fact, that's the case that can reveal errors all the way through your system. And so what the Quattrone Center has decided to do is we've created an expertise in conducting what we call just culture event reviews. And the purpose of a just culture event review is to take a case like what happened to John, or a case where something went wrong. And by the way, a case could go wrong in failing to get the right guy, too. If they'd gotten Kevin Freeman right at the get-go, that would have avoided a wrongful conviction, right? So we can actually help police and prosecutors by getting the right guy as much as we can help them learn from getting the wrong guy. And so we try to collaborate with all parts of the criminal justice system to help them do their jobs better. Right? Because if they do their jobs better, then the system is more efficient. And that's what we really want. We want a criminal justice system that works the way it's designed and that doesn't lead to the unintended outcomes like a wrongful conviction. I've got the wrong slides there. So the projects that we're working on these root cause analyses and audits. We're looking at conviction integrity units. A conviction integrity unit is an organization generally within a DA's office that is supposed to be kind of the prosecutorial response to the Innocence Project. So the Innocence Project comes and says, we've got a guy in prison who's convicted, and whatever his appeal process is, we think he's really innocent. So we want to come outside of court and figure out a way to solve this. And the conviction integrity units, which are now, there's about 22 of them throughout the United States, mostly in larger jurisdictions, and they say, we want to help you with that process. We want to look at those cases with you because we, these progressive prosecutors, we want to be ministers of justice, not simply people who get convictions. Now, these 22 things have come up kind of individually and voluntarily and very ad hoc, and so they all have different policies and procedures, and there's a wide variety of, to be really candid, some of them I think are really good units, and some of them are publicity stunts. And so we're doing research to try and figure out what makes a good unit, how can these units learn from each other? How can we help new units that are being created embrace best practices? And how can we help communities identify clearly which are the good units that should be praised and emulated, and which are the units that are more publicity stunts and need to be improved? We're looking at plea bargaining. So we're working with the San Francisco Public Defender to do the first systematic empiric study of plea bargaining in the last, I think, like 40 years. If you ask an individual public defender or an individual prosecutor, they will have a sense of what pleas they can get, and it's even different courtroom to courtroom within their court system. What they won't know is how their pleas are doing versus the lawyer next to them, and the public defender or the DA is unlikely to know what are the influencing factors that lead one person to get a particular plea and another person to get another. It's a huge black box that we know nothing about. And again, 97% of all the cases. And we know nothing about how or why the decisions are being made in any individual case, let alone the aggregate nature of that. So we're working, we've got about 3,500 cases from the public defender in San Francisco, and we're hoping to learn about whether there are racial disparities, whether it matters if your public defender speaks the same language as the client, what the influences might be of the judges involved, whatever we can learn there. We're looking at crime labs to work with their procedures, and in some ways crime labs are the easiest analogy, because so much of the scientific lab process that was used in nuclear management and healthcare applies directly to forensic labs. And we're looking at evolving science, so the junk science element there, which really I think is how can you help judges be better interpreters and assessors of the scientific information that comes into their courtroom. Because when you get a George Soliotis, an arson case, what you really have there is a judge. I went to law school right after I finished my diplomatic history degree, which I did after avoiding science my entire college career. I took chemistry and society in college. It was a multiple choice exam that included the question, how do you get a rust stain out of a lamb's wool sweater? Which one of these compounds? I got a B. Okay? You don't want me assessing your expert testimony, right? And we've got judges out there that lack my scientific background, that are making decisions about which expert should get in and which expert shouldn't and what should be expert testimony, right? That's going to be a problem, and we need to help judges get better at that. So I was reading To Err is Human. We'd started the Quattrone Center. I was filled with God, this was so awesome and so unique and so independent and so innovative, and I was so cool. And I was reading To Err is Human, and honestly, the executive summary, you can just take healthcare out and just put criminal justice in, and it fits all the way through. And then I got to the end, and they said, this is what we propose as the solution to our 100,000 deaths in healthcare. There should be a single group that's dedicated to improving and monitoring safety through the system. And I was like, maybe that's the Quattrone Center. Maybe that's what we can be. And they said, you should set national safety goals and track progress in meeting them. And I'm like, that's what we're going to do. And they said, you should develop a research agenda. I was like, check, right? They said, define prototype safety systems. I was like, let's do some pilot projects. That's brilliant. Then you should develop, disseminate, and evaluate tools for identifying and analyzing errors. Well, that's exactly what our collaborative model is supposed to do. We partner with these guys, we design a solution, and then we tell everybody in the world about it, so they'll pick it up and move it from there. And somewhere along here, I realized that actually this had been thought of in 1998. And all of my innovation was like, oh, yeah, this actually predates me by like 15 years. But it's really encouraging, actually, because if you think about where aviation and healthcare have gone, the aviation industry really started this 45 years ago, and they were starting at a time when there were 350 airplane crashes a year and very many fewer flights. We've now got 40 times the number of flights, and we've got a death rate of less than 2 in 1 million. And the reason is that aviation has developed all these tools for how to make themselves safer and how to learn from error. And they've developed a culture of coming forward with their errors, being transparent, being accountable, okay, and understanding that the safety of the system, that the legitimacy of the system depends on it. And because they've done that, millions of people fly, right? And that's what we want to do in criminal justice. We want to take it. There's nothing revolutionary here. We're just taking concepts that have worked in other disparate industries. We're applying them to criminal justice. And the reason we're doing that is so that what happened to John Thompson doesn't ever happen to anybody else. It just can't, right? I mean, and the fact of the matter is our criminal justice system might be 99% accurate, right? But 99% accuracy in aviation means 2 planes crash at O'Hare Airport every day, right? And a lot of people have asked me, well, what's the acceptable rate of error? And I say, 0. And they say, come on. We're humans, right? And I say, yeah, we're going to have errors. But the fact is, one error isn't acceptable when it's your wife, your son, your best friend, your dad, right? That one error is not acceptable. So are we going to continue to have errors? Yes. But can we continue to accept errors? Absolutely not. And we're blessed to have John here with us, and we're blessed to have Robert here with us. But the fact is, John's here because he was lucky. John's here because he was lucky, and we need to do better. That's it for me. I'd be happy to take any questions.